on the Planning and Development Amendment Bill 2016. I welcome, of course, the bill is finally before us, providing for the Office of the Planning Regulator, which, as you know, was a key recommendation from the Flood Mapping Tribunal. And I suppose our ordinary constituents and citizens, they welcome the whole idea of a regulator, because we often have a situation in planning where some perhaps crass development is proposed that's not sustainable or that's totally out of sync with the immediate district. And when people register their opposition to that, maybe they're supported by the council, and then when it goes to Bord Pleanála, perhaps Bord Pleanála overturns that, and the permission is granted. As it is now, your only recourse is to go to the High Court, I think, on a point of law. So at least now we have this regulator that our constituents can make a complaint to. So at that basic level, I think the idea of regulator is welcome. The Mapping Tribunal's, of course, final report was published in 2012 and gave 64 recommendations to the then government, and 10 of these 64 recommendations were in relation to the planning system, and of course the key recommendation being the need for an independent planning regulator. And this bill, of course, is part of a series of bills introduced by the government in what I still believe is a feeble attempt to address the housing crisis through the Construction 2020 strategy. And while the steps taken by these bills are to be welcome, it's a very, very slow process, Can. In fact, the end of this year, we still have a situation, of course, in my own constituency and obviously in many other urban areas where the desperate need of families in relation to housing is acute, and despite the rollout of the HAP programme, is in fact worsening. For most citizens, flood mapping over a 15-year lifetime revealed a history of brazen attempts to subvert the democratic planning process. And the failure to implement the Kenny Report of 1974 allowed the hoarding of huge land banks around the Greater Dublin region and similar practices around other cities and towns in Ireland. And then, of course, when development plans came along, councils were subjected to immense pressures. And it's very striking, of course, Can Corley, that while elected councillors are not the planning authority, they're not the housing authority, they're not the drainage authority. We used to have water when we were being charged of that when we were before Deputy O'Sullivan's government was there. We were the water authority and so on. But the councillors did have this unique power to rezone land in their functional area at the time of the development plans, you know, it's an extraordinary and important power, but it also obviously was open to very severe pressure. And hence, of course, we have the careers of lobbyists like Frank Dunlop and agents for the developers allegedly seeking to influence zoning and the shape of development plans. And while some conclusions of Flood Mapping may be rolled back, we read in recent reports, the tribunal clearly revealed very disturbing practices in the making of development plans. It also demonstrated, of course, a planning process for the development of our towns and cities which compares very unfavourably with the far more democratic and publicly controlled land zoning and planning systems in countries like Sweden, Norway, Finland and indeed in the United Kingdom. And I remember in particular in relation to my own region, the north fringe of Dublin City or the south fringe of Fingal, when we were shown comparisons with the cities of Stockholm and Amsterdam when they developed new urban regions, huge urban regions like we were developing or hoping to develop, of 20,000 to 30,000 homes with ancillary social services, schools, health centres, shopping centres and so on and so forth. The much more publicly controlled process in Sweden and in Holland. In relation to, by the way, to other findings of the Flood Mapping Tribunal, on a number of occasions, Can, in the 31st Dáil, I asked the Minister for Justice, Miss Deputy Frances Fitzgerald, and on Taoiseach to report on the current situation in regard to the investigations by An Garda Síochána and the Director of Public Prosecutions into the findings of Flood Mapping. The Minister told me in May 2015 that, and I quote, "As the Deputy may recall from my reply to his further question, number 491 of 24th of March, the position is that following the examination by An Garda Síochána of the report of the Moriarty Tribunal, the advice of the Director of Public Prosecutions was sought with a view to determining whether or not a full Garda investigation should be commenced. The Garda authorities have also been engaged in an examination of the report of the Mahon Tribunal, which was referred to the Garda Commissioner by the Government. This examination is ongoing at present." So perhaps the Minister for Planning, who has just left us, but he might refer in his reply to this debate participate to that examination of the report of the Mahon Tribunal, and whether the Government has received the report from the Garda Commissioner. The Minister might indicate if the examination is continuing, whether full Garda investigations are proceeding, and whether any file or files have been sent to the DPP. Chapter 2 on the establishment, functions, organisation and staffing of the Office of the Planning Regulator, of course, the heart of the bill. In section 31p, the key functions of the regulator include the evaluation of development plans, variations of plans, local area plans and the regional, spatial and economic strategy, all very important aspects of planning. Key power in section 31p1 is to bring a plan which the regulator considers deficient to the attention of the Minister for Housing, Planning, Community and Local Government. The Office also has important research, education and review function, and has to produce an annual report and statement of strategy. And I agree with Deputy O'Sullivan about the importance of planning, sustainable planning in creating, humane society in which people can live very comfortably. It's a critically important subject. The regulator, of course, has to take cognizance of the policies and aims of the government, the public interest, the EU directives on the environmental impact statements and studies, the Habitats Directive, the Boards Directives, and especially, of course, the National Planning Framework, which is given statutory basis, and I welcome that warmly in this bill. Planning regulator, of course, is appointed by the Minister in section 31W for 5 years following competition by the Public Appointments Commission, and the accounts to be audited by the CNAG and the annual report sent to relevant Oireachtas committee. So 2 committees in this House, the PAC and the Housing Committee, the Housing Planning Committee, will have the opportunity to question the regulator. They can send him or her a note asking her or him to attend. Deputy O'Sullivan, of course, feels that in her early contribution that the bill got things right in relation to the public control of planning. The helpful Bills Digest prepared very well, as always, by our Oireachtas Library and Research staff, of course, notes that the Mahon Tribunal actually recommended a post of independent planning regulator, as my colleague Deputy Collins has said, and that the Minister's power of enforcement and power to issue directions to planning authorities should be transferred to the new office. And the Joint Oireachtas Committee on Environment, Culture and the Gaeltacht, in their pre-legislative scrutiny in response to Minister Alan Kelly's General Scheme for Planning and Development No. 2 bill, agreed with Minister Kelly's recommendation that the final power to issue directions following assessment of local plans should rest with the Minister. But given the history of Flood Mahon, I fundamentally disagree and agree with my colleague and other colleagues who have spoken here tonight. I believe the planning regulator should be fully independent of government. After all, and this is the point I'd like to make especially to my colleague Deputy O'Sullivan, I'm informed by Minister Noonan. I asked Minister Noonan about insurance prices, car insurance going through the roof, our constituents screaming at us. He comes back with a long letter and says, I can't do anything about it because the central bank is independent. I asked in the past about energy prices, Deputy Rabbit and others when he was Minister. What are we going to do about the energy prices at the time going through the roof? Can't do anything. SARE is independent. I asked about Comreg, about the rip-offs we have in mobile phone telephony, which we still have, and we're not sure how that's going to pan out now with Brexit, roaming charges and all the rest. But Comreg again, oh no, Comreg's independent. Minister can't do nothing. So why should it be that in this area, in this vital area of planning, that the regulator shouldn't be fully independent? When an inspector is appointed, of course, and prepares a report, the bill is also unclear on whether the Minister may depart from a planning regulator recommendation after an investigative process has been completed by the regulator. The general scheme of the bill referred to periodic reviews of regulators under the OECD's best practice principles for transparency and accountability, but doesn't indicate how often this should take place. The revisions of the bill also have this lacuna, and it seems to be left to the regulator to conduct his or her own reviews of the performance of their own office. Obviously, our Oireachtas committees will keep an eye on the performance of the regulator, but again, that's something that maybe the Minister might look at in the final stages of the bill. The bill as presented does not make provision for the establishment of the National Register of Enforcement Orders and or sanctions imposed by courts for breaches of planning law. The Environment Committee of 31st Dáil called for such a register, and rightly so, so it would be possible to easily identify on a nationwide basis any developers in breach of planning law. And I think those of us As part of our job as public representatives representing our constituents who would generally know what developments are taking place around our constituency are interested to know in the track record of people who are particularly engaging in major commercial or housing developments. It's very disappointing to see the recommendation 6 of the Joint Oireachtas Committee on the Environment, Culture and Development report calling, and I quote, for the introduction of a National Register of enforcement orders and/or sanctions imposed by the courts for breach of planning law. According to the committee, it should be possible to readily identify on a nationwide basis any of those developers who engaged in serious or serial breaches of the law. So this doesn't seem to have been provided for in the bill. There's also a huge gap in legislation before us, or this is a huge gap and should be addressed at report stage. It recalls a bill, Can, that you may remember yourself. I mean, I was proud to support in the 28th Dáil. It was a bill, planning bill in the name of my great Fingal colleague, Deputy Sean Ryan, one of the greatest deputies who ever spoke in this House. And Deputy Ryan, he sought to, in his bill, to simply refuse any further planning permission to a developer who had failed to carry out the provisions of an earlier planning permission or to remedy major defects arising from the permission. We've seen permissions with horrendous defects, for example, in the North Fringe, and yet developers go forward and put forward a new development before the remediation has taken place or before we've had a chance to study their track record. Unfortunately, of course, Deputy Sean Ryan's bill, it was defeated by the Bertie Ahern and Mary Harney Fianna Fáil PD government, who refused to put any constraints on developers. In view of the planning history, of course, in section 31AL, I think the Code of Conduct is vitally necessary to relate to the management of conflicts of interest, and I note there will be a written policy document which sets out the need to disclose relevant relationships and interests within the regulator, memberships of other agencies, including memberships of other agencies, and of course, importantly, disclosing financial interests, whether work outside the office is taking place, any gifts, etc., and disclosing information which may be of importance to the work of the office, and of course lays down the best practice for reviewing and the management development plan submission. I didn't notice this, I may have missed it, Minister, whether or not there is a sort of cooling off period for the regulator and his staff. In other words, if the regulator comes out of the commission or of the Office of Regulator, will there be a period that person couldn't immediately go to work for a property company or for developers? Is there any intention to put in, or is it there? I didn't see it, to put in that type of provision, which I think we have in relation to other areas of the public service. And Section 31AS, I mean, I welcome the provision for reviews of those involved in planning and assistance of procedures, and that section sets out the parameters of the review, including the provision for sending the draft report of the review along with recommendations to the relevant planning authority and the other appropriate recipients. And I'm most familiar myself, of course, can correlate with the development plans of Dublin City Council, where I was proud to be a member for 12 years, and of course of Fingal County Council, which I'm proud to represent for the last whatever it is, years, 24, 25 years. And I think we were all educated in those, throughout those development plans, I think, to look for the highest standards of sustainable planning in our areas, particularly in major developments, and in our case, of course, in the sustainable development of the north side of Dublin City. I welcome the provision in 31AU, I think, for access to information during a review, and once an authorised person is assigned to review, the bill stresses he or she will have the authority to enter lands and other premises for inspection. Should someone, of course, not comply with an OPR, the Office of the Regulator request, or indeed obstruct, impede, or review, the bill provides for such obstruction, non-compliance, to be classified as an offence. And of course, employees and consultants working with the OPR will also be prohibited from disclosing information. Just when I was looking at that, though, I wondered how does that chime in with our Protected Disclosures Act of 2014. Obviously, in this House, during under your chairmanship, Cian Corla, we've had long discussions about the role of whistleblowers in the Garda Síochána and indeed in other organisations. So I just wonder how does that pan out with that section in relation to protected disclosures. How long have I left, Cian? Okay, thanks very much. And Chapter 2A of the bill provides for replacement, of course, of the National Spatial Strategy with the National Planning Framework, and I welcome that very much. Sometimes, though, I feel that there's often a kind of feeling among our rural colleagues that some way, everything goes to Dublin and so on and so forth. We, of course, feel the opposite, that the city hasn't been given the sufficient resources. I mean, if we want Dublin to be a Premier League capital city, which I think everyone does. It's heading for, in the Greater Dublin area, I suppose, for 2 million people. If we wanted to be a sort of Premier League city and a Premier capital of the European Union, we do have to put it in as an ambition, and that's why in the section of the framework, I think we should have a section talking about the capital city and saying that that city, will be planned, to the highest international standards. Now, I do feel in the past the McCreevy proposals, we came in here one budget day in the Charlie McCreevy, when Deputy McCreevy was Minister, of course, and he brought in decentralisation, which seemed to include a whole range of towns and indeed villages all across the country. I think that was the wrong approach, and I mean, I think that we should have concentrated while spreading development around the regions, but in particular, I suppose, Cork, Galway, Limerick, Waterford, maybe Sligo, Castlebar, Tralee, Letterkenny, the kind of, and perhaps the Athlone, Tullamore nexus in the Midlands. We should, I think, have concentrated on building up those cities, as to hold our populations, to give them the widest range of social services and indeed jobs, and to ensure that that happens. So I believe Dublin needs to be there, that the ambition should be there for Dublin as a Premier capital city, but also to develop Deputy O'Sullivan's city and all our other cities, as fine, important regional capitals as well. On the Section 20C, of course, subsection 2, the matters of the National Planning Framework will address our outline. As I said, I think it should include something on the capital. Such infrastructure, of course, includes water, waste, energy, health and the cultural requirements, and there's also a framework for maritime spatial planning on the Directive 2014-89 EU must also be established, and it will be reviewed, of course, every 6 years. So I welcome all of that. I do feel, as I said, I mentioned in relation to our own capital, that at times there's been a lack among our 4 councils of a cohesive plan for the region. In the south fringe of Fingal and the north fringe of Dublin, we've tended to find the planners of the 2 councils sort of doing their own thing and meeting very rarely to plan out what essentially, like in my own constituency, for example, if somebody lives in Dáil and somebody lives up the road in Donamead, they don't really think of themselves as being in 2 different local authorities. It's the same region, and I think one of the key failures of planning is that the north fringe of our city wasn't a single SDZ, strategic development zone, and I think that's something obviously that should be worked on for the future. That the councils, and indeed I was once a member of the Assembly for the Greater Dublin region, the Regional Assembly, and indeed the counties around Dublin, your own county, Kencorla, and the 4 Dublin counties, that we need to work together to have a sustainable and very hopefully a very fine urban environment. I do feel also, of course, that we do need a direct election for a mayor of the Dublin region, a cohesive plan for the region, and all the facilities we need for sustainable development. I certainly want to have Deputy O'Sullivan refer to developer-led planning, that we've kind of got rid of it. I don't think that's the reality. If you look at the kind of plans that are certainly coming before Dublin City, developers are still making the running. I agree with you, Deputy O'Sullivan. I think this House and the county councils, city councils, they're the ones that should make the running, have the master plan. And when we get that very clearly in place, for example, the North Fringe had a few lines scribbled on a page, not a detailed plan. When we get the plan together, that's the time to bring in the builders and let them build out the city. So I want to welcome the planning regulator with a few caveats that I've said. I would like the office to be fully independent, and a couple of issues that I've mentioned, I hope they will be addressed, but I do hope that it will be a step on the sustainable development for our whole country and the sustainable planning for our whole country. Thanks, Karen.
Thank you very much, Deputy.